Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, and holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for a
I feel like I'm missing something, but, well, what do you say? You take one single day off, and then you forget it all. I'm just joking. I hope everybody's doing well. I did indeed take yesterday off, but that is on the backs of good news that I will announce later in the show. Don't you worry. More Paisley to come. Let's put it that way. I am glad that you're all here. We have the beginning of a new case that is a grandparents' rights case. So we're going to get started on that. We're not going to watch the whole thing today because we also have members only. But we should get started. I would love to hear what you had maybe to eat today, for dinner, for breakfast, for lunch. I was woken up unceremoniously and rudely this morning by my roommate yelling, "Go to the gym, go to the gym, go to the gym, go to the gym." In reality, he wanted me to make him eggs, make him eggs, make him eggs. He was not so concerned about me going to the gym. Either way, I did not appreciate it. I am about to have my first coffee of the day. Ooh, that sounds good. I'm about to have my first coffee of the day. It's made in here and still hot because it's my Bubba mug. Anyways, so we are going to get going with the intro to this case, and then we'll get started with it. I mean, there's not much else to say to that. Not much else to say. That's funny, John. There is an ongoing joke in my house that you not only have to go to the gym, but you have to go inside. Thanks, Chips. But yes. Okay. Coffee, cheers. I'm drinking Tim Hortons coffee. You know how it goes. Let us get us going. There it is. There it is. Courtroom 474. Knock on the judge's door. Terrible singing, Paisley. Terrible singing. Just drink your coffee. You know what? Oh. Casey Carey, hugs for me and hugs for chat. I like it how it comes up like that. Oh, ma'am. Oh, and I do have two from Vicky before. Thank you for reminding me. Vicky's back in the crew, and she's been here for 10 dang months. Oh. No, Judge, wait. We're thanking Vicky. God, Judge. God. Sometimes he's so rude, this Judge. Thank you, Cellulite Yoga Pants, for keeping me aware. And Vicky, I got you now, girl. I got you, Vicky. Yeah, our favorite Jennifer Reed. And thank you for 10 months of support, Vicky. That is amazing. And thank you, Casey Carey, for the super chat. Oh, so glad to know that works. Okay. Like I said, this is grandparents' rights. I don't know anything about it, so let's figure it out together. Oh, I'm so proud of you. I am going to the gym today. Like, I am going. I may also be planning on picking up ice cream while I'm near the store, but that's besides the point. Because if I work out long enough, I can justify the ice cream. Anyways, okay. That is, in fact, my plan. I don't want him to hear. I really want a Coke float. That's what I want really bad. Really bad.
So many names.
A Coke float floats my boat. Oh. Ladies and gentlemen, table.
Oh, hold on. Carlina, their device is not connected to audio. Hear me.
Morning to everyone.
Good morning, Your Honor.
Good morning, Your Honor. This is the time and place set for the evidentiary hearing on the intervener's motion for grandparenting time. And Mr. Bartel, are you ready to proceed?
Yes, I am, Your Honor.
Ms. Reed?
Yes, I am, Your Honor.
Okay. Mr. Bartel, are there any preliminary matters before we commence?
The only thing I would indicate, at least on my end, Your Honor, I have Dr. Haugen. He's not able to appear today. I don't know how long testimony will take. So I would ask that, and as this court knows, he's testified in this court many times before. He has conflicts at times. He can appear for October 1st. So I would just like to make note of that in case we have to go out of order.
Okay. Ms. Reed, is there any problem with taking Dr. Haugen out of order?
There's not a problem with taking Dr. Haugen out of order, but I would object to Dr. Haugen testifying as a witness since he has not examined this child. There's been no psychological assessments of this child by Dr. Haugen. He hasn't met this child, so any testimony would be pure speculation.
Okay, well, what we'll do is, obviously, as you have no trouble taking him out of order, then we'll address that at the time that Dr. Haugen's going to testify. You can raise the objection at that time. I'm just making note. Anything that you have, Ms. Reed, preliminarily before we commence?
Preliminarily, I have the motion for summary disposition that we filed. And then I also wanted to do a motion in limine to have Mr. Bartel make a specific offer of proof regarding the relevant testimony of these 17 witnesses on his witness list. Again, it's our opinion that none of these witnesses have had any contact with the parties, my clients, or this child in almost a year now. So how are they going to be able to testify of firsthand knowledge of substantial risk of harm to this child or in the best interest of this child when they have not had contact with her?
Okay, well, court's not going to, I guess you'd say, prematurely determine what the witnesses may or may not testify to, or what the basis for their testimony may be. As we get to each witness, we can address that. But again, to do otherwise, the court would be basically looking at and total conjecture as to what they may testify. I don't know what they've seen or what they have not seen, et cetera. So at this point, I'm going to deny your motion in limine, and I'm not going to require Mr. Bartel to give an offer of proof as to any of the particular witnesses. He can call the witnesses as you normally would call them. Ms. Reed, if you want to go ahead with your motion for summary disposition, you can go ahead.
I'm not going to repeat everything contained in the motion, as I'm sure the court has read it, and I've read Mr. Bartel's response. But the basics is, even if all the claims in the motion are true, for argument's sake, the grandparents have failed to allege that Ari is an unfit parent. They have failed to allege any substantial risk of harm to the child's mental, physical, or emotional well-being created by Ari's decision to deny grandparenting time. And as a matter of law, they cannot rebut that or overcome the presumption. That's again in their own motion. They only say that they only use the word detriment or detrimental, and that is not the correct or required legal standard, nor is it a detriment or detrimental to the child to deny grandparenting time when the child does not want to see the grandparents. She's old enough to state her preference. I believe the court interviewed the child in this matter. And if she's any way consistent with what she's repeatedly told my client, she probably informed the court she does not want to see the grandparents. So now the grandparents are trying to claim that there is a substantial risk of harm and we just don't see it. And I don't see how they can claim a substantial risk of harm when they waited 6 months after they had not seen this child to file this motion. If there was a substantial risk of harm to this child, they would have filed it immediately in November when that contact was stopped. Further, like I had just previously said, none of these witnesses have seen or had significant contact with the child in almost a year now. The grandparents haven't had contact with the child in almost a year now, so they have no firsthand knowledge about her mental, emotional, or physical well-being. They are also out of touch with this child. They don't even know that she can write. They don't know how she's doing in school. And the Court of Appeals had already reviewed the motion and the affidavit and our response and had determined that the record does not reveal that there was deference given to the plaintiff's decision to deny grandparenting time or that the grandparents rebutted that presumption. And they've already reviewed everything that we believe that they can offer. So what additional information can they provide to the court when they have not seen this child in this long to rebut that presumption? They just can't. There hasn't been any harm done to the child. There's no risk of harm being done to the child as a result of the denial of grandparenting time. But there has been harm done to the child through mental and emotional abuse by the grandparents telling the child that Ari is not her father, taking a scorched earth approach to impose their will on this 6-year-old when she does not want to go, causing immense financial harm and strain to my client having to litigate this to defend his constitutional right as a parent and protect the child's wishes and desires from being forced into time and a relationship with someone she does not want. Grandparents have established immense hostility towards my client via efforts trying to force grandparenting time, trying to find him in contempt, blasting him all over Facebook, calling him disgusting and that he's sick, and telling this child to conceal and lie to her father, that he's not the father, which is greatly upsetting to this child, and that impacts their own moral fitness. So in all, it's clear that Ari has a constitutionally protected right to make decisions about the care, custody, and management of his child.
Martha D, thank you so much. That's awesome. Members only coming up after this, guys, at 2:15 in an hour, 15 minutes. We'll probably do another hour or so of this. There's like 6 hours of it. And we'll see how far we get. Sounds like, from what I can gather, we have, I think mom is in jail. These are mom's parents. This is dad. Mom's parents want access to the child while she's in jail. And dad's saying no. I don't know. We have to listen to more, but let's see what happens. And thank you again, Martha.
And that also includes who the child sees and does not see. And the court recognizes the presumption that a fit parent will act in the best interest of their child. They cannot rebut the presumption. Their motion doesn't even mention the presumption or any indication that they can. Now, I have read Mr. Bartel's response, and he kind of alludes that I asked for a adjournment for maybe improper means to file a motion for summary disposition, and that's not true. I had concerns that this was going to be a trial of ambush, and I think my concerns were valid, being that now we have a 17-person witness list, and this was scheduled this late because Mr. Bartell had a scheduling conflict earlier, because I do believe the first date we were given was the 5th of this month. I had the appropriate time, so I believed it was appropriate to file this because we do not believe, and that it has been sufficiently pled on its face, that the facts are supported or that the statutory requirements have been met in the motion itself, or that there can be any evidence to back up that motion for itself. We did ask for an evidentiary hearing in our various pleadings because at that time, the court had already entered the order for grandparenting time, and we believed that the court could not do so without having a hearing regarding the rebuttal of the presumption or the best interest of the child, and I believe the Court of Appeals agreed. So that's why we're not going like back and forth and asking for two separate things. We're saying now the grandparenting time order was entered. That was not correct. We needed to have a hearing if it was going to be the case, but we're now saying they don't even pass step one to get the motion to that point of having to be able to present evidence of the best interest of the child, because that's what the statute requires. First, it has to be the rebuttal of the presumption that Ari's decision creates a substantial risk of harm, and then we get into the best interest factors, and their motion falls flat on its face. So we're requesting that this be denied. If the court would not deny their motion outright, we are requesting that the hearing be bifurcated to follow the statutory requirement that first they must rebut that presumption, and then we get into the best interest factors. And it does not, like Mr. Bartell says, it's not interrelated. The statute's pretty clear that first they have to rebut the presumption before they can go any further.
Okay. Mr. Bartell?
Well, I mean, let me start off. There was a lot of facts presented by the other side that clearly warrants this hearing, Your Honor. I mean, when we have plaintiff's counsel just making all these allegations, it's clear that's what she is relying on. The interesting thing here, Your Honor, is, and I did point out, there was it was about 11 or 12 page motion for summary disposition filed in the afternoon after they filed an ex parte motion to adjourn out a hearing, claiming there was trial by ambush, claiming we didn't follow the court rules, but we did, by not having to provide, and I don't have to go through all that, but obviously inaccurately giving this court information as to the law, not candor to the court. And then all of a sudden, the third motion of the week, because the next day after the motion for summary disposition, they file a motion for counseling. It's quite suspect, Your Honor. It became abundantly clear that's what they wanted. But first, their motion for summary judgment is actually really a motion for reconsideration. I say that because they're making exactly the same arguments, Your Honor, as they made in their initial answer to this court. This court already made its determination. There was sufficient evidence to proceed forward to an evidentiary hearing in this matter. But even more importantly, and isn't even addressed by plaintiff in oral argument, is that they requested not just to have an evidentiary hearing with the Court of Appeals. They actually requested multiple things. So now to couch it in the terms of, well, we asked for an evidentiary hearing only because there was a temporary order entered, that makes no sense. Further, the Court of Appeals in its order ordered, Your Honor, there to be an evidentiary hearing. And plaintiff fails to present that or address that with the court. It is very clear that this was an improper motion. If we want to talk about unnecessary delay if we want to talk about unnecessary costs, perhaps plaintiff and his counsel need to kind of look at all their filings, in which there was, I think, 5 filings within a 2-week period, and further that they're not even following and cherry picking what they want to see, but they're not even following the Court of Appeals directive. Okay. The Court of Appeals overturning this court on the temporary basis has nothing to do with an evidentiary hearing, and actually has nothing to do with the long-term potential order of this court. And to try to mix those two issues.
Where's the judge, Aaron? You can't talk without the judge there. I think that is mom in the middle top square row. This is gonna be painful. This is gonna be slow. I wish this guy would figure it out how to get on with the show.
Issues together is sloppy at best. So, Your Honor, we have to follow the Court of Appeals. Okay. And it said to go have the evidentiary hearing. And in fact,
Aaron, we lost Judge.
Yeah.
Hold on.
oh,
Sorry, yeah.
Do you know-
have to.
do you recall when?
Say what?
Do you recall when in my argument?
Maybe the last 30 seconds or 20 seconds. Let me turn on the ring. I lost.
They actually had to go offline and then come back to it. Give me a moment here while I grab it for us. Grab it for us. I couldn't download this one. Too long.
You out, Mr. Bartel, so you can, I guess, restart from where you lost me.
Unfortunately, I don't know where I lost you, Your Honor. So I will try the best where I think I left off. But
Okay.
The long and short of it still, Your Honor, is that the Court of Appeals made a determination in its order. It was a short order, but it actually indicated to actually have the evidentiary hearing. Okay. And plaintiffs don't address that. They clearly don't dispute it. Otherwise, they would have addressed it. And that is why I'm actually asking Your Honor, at a minimum, I mean, I think costs are really warranted here. That is a prime example of a frivolous filing in a court where you already made the determination. Okay. The Court of Appeals had all that information in front of it. And the only thing the Court of Appeals did was just disagreed with your decision on a temporary basis. And further, the order said,
Buddy, if the Court of Appeals disagreed with his decision, you are not getting fees for her having to file this. I'm sorry, but that doesn't make any sense to me. Like, just because the judge was told that that was the wrong decision, I guess. Ow. My neck.
that go have the evidentiary. I mean, it couldn't be much more clear. You're going to have an evidentiary here. They actually said that. And yet we have Miss Reed, and I should say the plaintiff, filing this motion that we have to answer, Your Honor. That is frivolous. Okay. If that's not frivolous, I don't know what is, because you already had 2 orders. And if they were going to file a motion for reconsideration, they should have followed the court rules, which would have been within 21 days of the order being entered, and they didn't do so. So they're actually coming back still and arguing all the exact same things. I do want to make note of one other thing. I keep hearing about now it's about a year. The months keep on, 1 week turns into 2 months for them. It has not been a year. But regardless, MCL 722.27B1F provides that grandparents can even petition in the year preceding the commencement of an action under subsection 3 for grandparenting time. If the
Vince, we missed you. Were your ears burning? Hi, how are you? And thank you for 3 months support. These are petty grandparents trying to get grandparent time. Well, I don't know. I assume everybody in court is petty, but that's you. That's just me. That's just me being me.
the grandparent providing an established custodial environment for the child, whether or not the grandparent had custody under a court order. We had alleged in our motion that there was continuous and constant contact. It wasn't sporadic. It wasn't just a day here or there. It was on a routine, weekly basis that my clients saw this child and that they had this close bonded connection that was established. So every time I hear plaintiff keep saying about this whole period of time, the legislature clearly understood when it enacted these statutes that there may be a time period in between. And furthermore, if plaintiff would have looked at some cases out there, there are times in which there was a significant gap, not just a month or two, okay? Furthermore, there have been cases out there in which evidentiary hearings were held over a 3-4 day period, over a long period of time, in which the grandparents had not seen the minor child, and yet the trial court gave grandparenting time, and further, the Court of Appeals has affirmed such decisions. So this whole hasn't seen the child, all this stuff, so they don't know schoolwork and all this other stuff. That is not the law. I would submit to the court based upon the decisions out there. To circle back, I really do think sanctions are appropriate, Your Honor. I really do. We had to waste time to answer a motion that was clearly decided 2 times, filed on the same day after they wanted the evidentiary hearing adjourned for their benefit. There's no trial by ambush just because we filed the court orders as to whether or not there's trial, witness lists or exhibits, etc. We followed the court rules except for that one subpoena that got out late, providing to opposing counsel. We followed the court rules in terms of providing the information as required by the court rules. So I would ask for sanctions, attorney's fees and costs, and having to answer this frivolous motion. The second part, Your Honor, is the bifurcation issue. That is hard, as I indicated, to try to bifurcate the best interest factors with the rebuttable presumption that there's a substantial risk of harm to the minor child's mental, psychological, or physical well-being is hard to parse through. Further, as I had noted before, and counsel was agreeable that Dr. Haugen can testify at I think it's October 1st date, he is part of that rebutting of the presumption, notwithstanding the presentation by plaintiff that he has nothing to add because he's never seen the child. Once again, there are plenty of court appeals decisions where they have psychologists, not a social worker, testify as to generalities in which trial courts have, our trial court can actually take that testimony as information with regards to the particular matter. So I would ask for us just to proceed forward and present our case with all the witnesses. This court has the ability to parse through all of that information and issue the decision that this court deems reasonable.
Okay, thank you. Ms. Reed, anything else?
Disagree that this is a frivolous motion or that it was filed frivolously. We follow the court rules regarding motions for summary disposition. This is not a motion for reconsideration. It's basically on the motion itself fails to plead sufficient facts.
Okay.
And so it should be dismissed outright. And the Court of Appeals specifically found that the record does not meet their requirements either for a temporary order. So we're asking again for it to be dismissed.
Okay, thank you. Well, the court notes that this motion is filed under 2.116 paren C paren H, stating that the opposing party has failed to state a claim upon which relief can be granted. In this case, as the attorneys know, that a C8 motion tests the legal sufficiency of the claim based on the factual allegations in the complaint. The trial court must accept all factual allegations as true in deciding the motion on the pleadings alone. And a C8 motion may only be granted when the claim is so clearly unenforceable that no factual development possibly justify the recovery. I would take umbrage with Ms. Reed's rendition of the Court of Appeals decision, as the Court of Appeals in this particular matter stated that on the temporary basis that the court had not considered the fit parent presumption, not that it didn't exist or that it had some way was not able to be established in this particular matter. So notwithstanding the court having taken that into consideration, the court unfortunately didn't mention the magic words when I made my ruling, and therefore the Court of Appeals again, I guess, inferred or presumed that it had not been considered. In this particular matter, when the court does look at the motion for grandparenting time and looks at those allegations, the interveners had substantial paragraphs addressing the contact with the child and how substantial it is. Now, looking at specifically, court looks at paragraph 27. Paragraph 27 says that on March 1, 2021, plaintiff father's wife showed up at the petitioner's doorstep with Chloe, and she told petitioners that plaintiff father and his wife would let petitioner see Chloe since it was extremely important for Chloe's mental health for such connection to remain. Further, it's stated in the complaint that, again, at that point when the intervener was watching Chloe, that she, in fact, quit her job so that she could do that. And paragraph 42 says, even some of plaintiff father's own family believes it would be in the best interest of Chloe for the paternal grandparents to have, or maternal grandparents to have parenting time with Chloe, and that to order otherwise would be detrimental to the minor child. Then the intervener, Carlina Toledo, said in paragraph 9 of her affidavit, which was in support of her motion, says to not let grandparenting time would be to the detriment of Chloe's mental, physical, and emotional health. Paragraph 10, she says, Chloe loves us, and my understanding is that she has been told that we do not love her. However, when Chloe was told recently that myself and my husband love and miss her, Chloe was excited in case she loves and misses us as well. Paragraph 11 of the affidavit says, I have heard from individuals that still see the father and Chloe that they have told me that Chloe is depressed and misses my husband and myself. Paragraph 14, when Chloe would go home from my residence, when I would not receive routine time with Chloe up until the end of December 2023, Chloe would be very depressed. However, Chloe would be so happy that she would come back to my residence. In this matter, the court, in a motion for summary disposition, has to look at the motion in the context that the court will look at it and give the benefit in the motions to the non-moving party. And when I do that in context of the recitation that I just did, as well as looking at the entire motion and the affidavit in this matter, the court does not believe that, as asserted by plaintiff, that the interveners have failed to set forth a valid claim in this matter. The court will deny the motion for summary disposition. With that, Mr. Bartel, do you wish to make an opening statement, reserve your opening statement, or and proceed with proofs?
Just a real brief one, Your Honor. In this manner, I think the proofs are going to show that there has been significant contacts with the grandparents. I think the proofs will also show that there has been kind of a up and down relationship, so to speak, between plaintiff, his current wife, Kelsey Cronkite, and the grandparents, maternal grandparents. Our position is that this rockiness is not from the grandparents. The grandparents actually, believe it or not, care for plaintiff still after all this. And they want nothing but everyone to come together. They actually think it'd be in the best interest of this child to not, unfortunately, always be put in the middle. And I think the history will also show, if we're going to go back, that plaintiff father, whether that's him, whether or not he is being, I don't want to say controlled, but our fear is that his wife controls everything that's going on, is that we're put in this situation where the minor child has been put in the middle and used as a pawn. Unfortunately, there have been times where plaintiff has allowed the grandparents to see the minor child, and then he would yank them away. But I would submit, I think the proofs are going to show, as of most recent, up until the time, which is about the beginning of December of 2023, that plaintiff took the minor child from the grandparents and would not let them see the minor child anymore. Okay. And the proofs are going to show that the plaintiff has taken significant steps, including making unilateral decisions when there's joint legal custody, I think, to better his position. Unfortunately, what we're here still on is Chloe, what's in her best interests. I think the proofs are going to show that the grandparents aren't here to take away the minor child from plaintiff whatsoever. It's just that they had extensive ties to this minor child since the child was born. And those ties, I think, should continue based upon the
Oh my goodness, Sally Port, thank you so much for 10 gifted memberships. Look at all those names. I saw them all get given out. Oh, I love it when we see a name from the past. Billy Elliott on that list. Amongst others. I'm so thankful. So thankful. And also, Jude, I'm glad you're here too. 4 months. That's amazing. Also, what mug is he drinking from? Is that the label on the bottom still? Also, Jody, I'm glad that you're here. I'm sorry that you're sick. We're glad that you're here. I'm sorry that I get distracted by crazy things like this. I just feel like why the tag seems like it's just a weird thing to see on the bottom. Thank you again, Sally Port, 10. I can't believe it. What a lovely thing. And we are having members only today at 2:15 Pacific, which is what, 5:15 East? My brain. That's soon. We're only watching a little bit more of this. This is going to be a series because these people are fighting for fucking ever. Hi, Tin Man. But we are. We'll listen to probably another half hour. Then we'll take a 10-minute break, and then we'll be back for members only, where we're going to talk about ice cream. Yeah, that's right, ice cream, baby.
The proofs that are going to be presented, including the testimony that you'll hear from Dr. Haugen, who's a psychologist, that he'll be able to walk the court through as to the harms to the minor child, since there has been a cutoff of communication, contact, not only actually with the grandparents, but also with the mother, Taylor Morgan, because plaintiff does not allow the minor child to engage by phone or otherwise with Taylor Morgan. So this is where we're at, Your Honors. There's been a total cutoff of the minor child being able to have communication with her mother, grandparents, and everyone on that side of the family. And I think the proofs will show there is a substantial risk of harm to the minor child's emotional, psychological well-being in this matter. Thank you.
Okay, thank you. Ms. Reed, do you wish to make an opening statement, reserve your opening statement, or waive your opening statement?
I'm just going to rely on our motion for summary disposition as it restates our position, and that we believe that the testimony will not show any substantial risk of harm to this child, that she has not been harmed in any way. There's no risk of harm. Any harm that has occurred is as a result of the grandparents' own actions in false information that they're telling this child about their father, and that is the reason why grandparenting time is being denied, and that it would be a risk of harm to a harm to this child to force her to go for grandparenting time and do something that she does not want to do.
Okay, thank you. Okay, Mr. Bartel, you can call your first witness.
I would call Kelsey Cronkite.
Okay.
One moment, let me get her here.
What was that?
Okay. Good morning, Ms. Concrete. We're going to take some testimony from you, so we'll have to have you raise your right hand, be sworn in, and then we'll proceed.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes, I do.
Okay. Go ahead, Mr. Bartel.
Yes, can you state your name for the record and spell your last name?
Kelsey Lynn Cronkite, Cronkhite.
Okay. And where do you live right now?
730 Rex Avenue, Kalamazoo, Michigan, 49048.
What city was that you said?
Kalamazoo, Michigan.
And how long have you been living there?
Since this last Thursday.
And who lives with you?
My husband, Ori Cronkite, and our 3 children, Chloe Cronkite, Uriah Cronkite, and Giovanni Cronkite.
Now, when you say your 3 children, you admit Chloe Cronkite.
My stepdaughter, yes, sir.
Okay. And how old is Chloe?
She's 6 years old.
And when's her date of birth?
April 12th, 2018.
And what grade is she in school?
First grade.
And where is she going to school?
Comstock Elementary School.
And when was she enrolled at Comstock Elementary School?
Before school started in the beginning of August.
Okay, so just recently.
Yes, because we just recently moved here and bought this home, sir.
And when did you and Mr. Cronkite get together?
We got together in July of 2019,
And when did you marry?
December 6th of 2019.
And do you know Carlina Toledo and Jamie Morgan?
Yes, I do.
And how do you know them?
They are Chloe's maternal grandparents.
And do you know Taylor Morgan?
Yes, I do.
And how do you know Taylor Morgan?
Because she's Chloe's mother.
Okay. And when is the last time you've had any communication with Carlina and Jamie Morgan?
The day after Thanksgiving. So November of 2023, the end of November.
And when is the last time you had any communication with Taylor Morgan?
When we took kids on spring break to Tampa, Florida. And Chloe and I and Ori and Taylor had a phone call on the beach. I do believe it was March 5th.
Of this year?
Yes, sir.
And would you have routine contact with Taylor Morgan over the last few years?
Periodically.
And with regards to, would you admit that before December 2023, that Carlina and Jamie Morgan had significant contacts with Chloe?
No, sir.
Okay.
They had
How,
occasional contact.
I'm sorry?
Occasional contact.
So what is occasional contact to you?
They had Chloe on when she started school. They got to see her on Wednesday from 4 p.m. to 8 p.m.
And that is the only time.
They would call sometimes and ask for her to spend the night sometimes, and she would spend the night. Yeah.
Okay, let's go back to 2023. Approximately how many overnights would you say that Chloe had with Carlina and Jamie?
As I stated before, once Chloe started school, she had no overnights with Jamie and Carlina unless they asked for her to spend the night specifically because she started school. So school started in last year in 2023. It started in the end of August, I believe. So from August, September, October, November. So for the last 4 months of the relationship they shared, they only seen Chloe on Wednesday from 4 to 8, unless they contacted Ori or myself and asked for an overnight visit.
Thank you for the answer. My question was in 2023, how many overnights approximately did they have with Chloe?
I maybe a couple. It was sparingly.
How about 2022? How many overnights would you approximate that the grandparents had with Chloe?
In 2022, probably 1 to 2 nights a week.
And was that for the whole year?
There were times where Carlina Toledo would threaten us with you. And say that if we didn't allow Chloe to stay longer, that she would take us to court because she didn't agree with us not letting her keep Chloe for longer than what we thought was okay.
So how did that answer my question of 1 to 2 times a week? I'm just asking how many times.
1 to 2 times a week.
What is your background education?
I have a high school diploma and I have some college experience.
Okay. And I just want to make sure you have no hearing issues, correct?
Yes, sir.
And so in 2022, there'd be on average 1 to 2 overnights per week, correct?
Correct, sir.
And what you're saying is that there was less contact in 2023 with regards to overnights, correct?
Correct.
And you're saying it was more of a once per week, 4 to 8 p.m. on Wednesdays, if I understand, correct? Did there come a time that you were mad at Carlina for taking Chloe shopping too often?
I'm gonna object to relevance.
Mr. Bartlett?
Well, it's just going into the part of the whole background for this court as to the deterioration of the relationship. And I think also the control of the stepmother in this matter.
Okay. Well, it may be a little bit attenuated, but the court will allow it. Go ahead. Why don't you
Can you
ask
repeat the
again, Mr.
question,
Patel?
sir?
Okay. Did there come a point where you got mad at Carlina for taking Chloe shopping too often?
I was never mad at Carlina, but I did ask her to stop taking Chloe shopping so close to Christmas. Yes, sir.
Well, isn't it true you thought that she was just buying too much stuff for Chloe?
Yeah. Yes, sir.
And isn't it true that you kind of got heated in some text messages to her telling her not to do that?
No, I asked her respectfully, sir.
Okay. Isn't it true that you also got mad at her because she took Chloe to Chuck E. Cheese too much?
Yes, sir.
Okay. Isn't it true that you just thought that they bought a bunch of stuff for Chloe and you just didn't want that, correct?
I'm gonna
No,
object
sir.
again, Your Honor. I don't see how this is relevant to grandparenting time today.
It is.
Well, Your Honor, this is part of the whole thing. I think it is relevant for the court to understand as to the prior relationship between the respective parties to the breakdown of the relationship. I mean, you can't just jump in and have a psychologist say, here's the detriment to a child if you don't have this connection, and here's the context. I think you have to have the whole context here.
Okay. Well, what the court's going to do, the court will allow the question because obviously the court does need to know the, again, the environment and gets to know what the contact was and, all of that background to, again, address the best interest if we get to that point. So I am going to allow it. Go ahead.
All right. Isn't it true that you were not happy with Carlina, that you thought she was just buying her too much stuff?
I guess so.
Yeah. And I guess I want to back up. Wasn't there a time in which would you admit that there was kind of a rocky up and down relationship between you and Carlina?
Yes.
And would you admit that there was periods of time that you had previously withheld Chloe from her grandparents prior to November or December of 2023?
I'm not Chloe's mother, so I'm not the one that makes those decisions, sir.
Okay. But you're not the mother, but you would voice displeasure in other subjects to Carlina, correct?
I don't understand the question.
So you pick and choose which areas you are going to be the mother or not the mother of Chloe and voice displeasure to Chloe or to Carlina?
No, sir. My daughter has a father. His name is Ori Cronkite, and he makes the decisions for her. I would
So
always
why,
communicate with my husband before making any decisions about what I was doing with Jamie or Carlina Toledo.
so why were you having those communications then with Carlina and not the father of the child?
Because we were women and we were getting along at that point in time. We had a friendship.
But you agree those were duties for the parent to address, correct?
Correct.
Would you agree that Carlina and Jamie have provided significant sums of money to you and Ori in support of
No,
Chloe?
no, I don't agree with that whatsoever at all.
Would you agree that they gave you guys money, period, in support of
No,
Chloe? Okay.
no, they never gave us money.
Okay. Would you agree that Jamie and Carlina would purchase items for Chloe?
Yeah, they purchased items for Chloe like school clothes when Chloe's mother, Taylor, wasn't there and able to do so.
So anything else beyond school clothes that they would purchase?
She bought her some Claritin.
Isn't it true that you would be texting Carlina saying we need new snow pants for Chloe?
Yeah, I did ask her to get Chloe a pair of snow pants. Yes,
And
I
isn't
did.
it true you would say, hey, why don't you just have your mom? She's got Kohl's cash and she can go pick up some stuff for Chloe.
Mr. Bartell, that's the relationship we shared at that point in time.
Your Honor, I'm going to ask that she answer the question rather than be combative to me.
Ma'am, just answer the question. He's asked if you did that. You don't need to give
Can you re-ask the question, sir?
Isn't it true that you had asked or told Carlina just to have her mother, Gloria, to use her Kohl's cash to buy clothes for Chloe?
I don't remember doing that, no, sir.
Isn't it true that Carlina would bring medicine over when the children were sick, including your own children?
I just told you she brought Chloe some Claritin. And
But isn't it true that there were times when Chloe had the flu or was really sick in which she would purchase medicine or food for you guys and Chloe?
no, sir, that's incorrect.
So she didn't bring over Pedialyte and chicken noodle soup like in your text message to Carlina?
For Chloe, not for my children.
Isn't it true that there had been at least on one occasion, if not more, that you would ask Carlina and Jamie to take Chloe because Chloe was sick?
No, sir, that's not true.
And you never at any point texted Carlina that?
I don't believe so, no.
Okay. And you realize you're under oath here today?
Yes, sir. I do not remember ever texting Carlina and asking her to take Chloe because she was sick. I do not recall.
Did you ever ask Carlina to take Chloe because you or Ori were sick?
Yeah, that's a very good possibility.
So let me ask you, on your side of the family, when I say your side, let me define that. I'm talking about your grandparents, your parents, siblings, and Ori's as well.
Yes, sir.
Are there people on your side of the family that routinely see Chloe?
Yes, sir.
About how many?
Everyone.
Yeah, but how many?
Um, sh- we have at least 4 sets of grandparents, um, numerous cousins, numerous aunts and uncles.
And at any time, would you have Chloe spend the night with any of them over the last 2 or 3 years?
Occasionally, yes.
Let me ask it differently. Are they more than willing to take Chloe in times of need?
My family members,
Yes.
yes.
Isn't it true that you used to appreciate uh, Carlina?
One time, yes.
And isn't it true that you had showed up at her house or in another mode of communication, told her that it would be in the best interest for Chloe to have contact with her and Jamie?
Yes, I did.
Okay. And that was back in March of what year?
I don't have a very good memory, so I apologize.
I
But
mean,
that,
if it was in 2022, if would it be around 2022?
no, it was probably 2021.
And you don't lie, correct?
Correct.
Okay.
Are you asking me if I lie? I plead the fifth on that.
Isn't it true? I want to get back that Carlina gave money to purchase photographs of Chloe.
Yes, sir, but the photographs were for herself and for her family.
And you agree, would you guys would be in contact on a routine basis in 2022 and most of 2023?
Can you ask that question again, sir?
Isn't it true that you and Carlina were in I say constant, but frequent contact with Carlina in 2022 and 2023?
Partially in 2023, and also partially in 2022.
And wasn't most of every, I'm sorry?
I just said it wasn't ever steady.
And isn't it true that most of your communication was concerning Chloe
Yes.
and concerning how she was doing and what was going on in school?
There was only 4 months where we would have talked about school.
Okay. During that 4 month period, did you talk about school with Carlina?
Occasionally, yeah.
Okay. But prior to that school 4 month period, you would be talking though about Chloe and what was going on with Chloe and what's going on in her life and how she was doing, correct?
Yes, sir.
So you don't deny that obviously Carlina had an interest in Chloe and a connection there on that level.
No, I don't deny that.
So when is it your understanding that Miss Morgan has been started her incarceration. And I mean jail and prison.
It was July of 2022 or June of 2022.
Okay. So is it fair to say about a year and a half she was
I guess.
in jail or prison prior to the maternal grandparents from just being able to see Chloe anymore?
I don't understand the question.
It was about a year and a half period that she was incarcerated while Carlina and Jamie were having contact with Chloe.
I guess. I said it was
And
June of 2022.
yeah. So how often would you be in contact with Taylor Morgan between June of 22 into the present?
My husband contacted her. He wrote her a letter in prison and had her call him. And that's when we started talking to Taylor. I think it was right before Christmas December of 2023.
So isn't it true that you did talk to Taylor Morgan for about a 2-month period in December and January of 2023 into 2024?
Yes, sir.
And is it fair to say that after about end of January, beginning of February, you had only that one more contact with Taylor on March 5th when you were in Florida?
No, sir, we had contact all the way up until when we were in Florida on spring break.
Okay, so you haven't had any contact with her since March 5th.
No, she just stopped calling and stopped talking to us. She stopped writing us. She stopped sending letters to Chloe. She quit calling both of our
So
phones. We
so
can't call.
how often were you sending letters to Taylor?
I sent her like 6 or 7 letters, and I sent her some pictures of Chloe.
And that was all in that December, January, February period?
December, January, February, and March. Yes, sir.
But you have not sent anything since March of 2024.
I don't believe so. I would have to double check and look and see.
Isn't it true during that time period that you did have communication with Miss Morgan, that you were trying to convince her to sign off on her legal custody rights?
No, sir, I do not recollect that.
You never did.
No, sir.
Isn't it true that when you were having conversations, at least on one occasion, with Taylor Morgan, you were telling Chloe to tell Taylor Morgan that Carlina was telling Chloe that Ori is
I
not her
object, Your
father?
Honor. There's a whole lot of hearsay in that.
That's not hearsay. That's coming from the source.
So
That's not
what my
hearsay.
understanding of all of that was Kelsey's telling Chloe to tell Taylor something else that someone said.
Correct.
Yes. And that Taylor don't speak. Your Honor, that's not hearsay. If I asked someone if they told someone to tell someone something, it was convoluted from the standpoint of having someone tell someone to tell someone, but it's not hearsay because she's telling the person to say it. That was the question.
Okay, well, clarify the question because it was a little bit confusing, Mr. Bartel.
Yeah, and I don't know how to clarify it up more, but I'll do my best, Your Honor.
Okay.
Is it not true that at least on one occasion that you told Chloe, so this is a statement that you told to Chloe, to tell her mother, Taylor, that Taylor's mother was saying that Ori is not Chloe's father.
That is not true. No.
Isn't it true you told Chloe to say that at least 4 or 5 times when Chloe was on the phone with Taylor?
No, sir, that's not true.
Isn't it true that you had told Carlina Toledo that at the end of November or the beginning of December of 2023 that you guys needed to sit down?
Was that the end of your question?
Yes,
That we need to sit down?
you needed to have a sit down.
I asked her probably in the beginning of November.
Isn't it true that you brought up the fact that you wanted Taylor to sign off on legal custody?
No, sir.
Isn't it true that you indicated that you were dealing with a State Farm insurance proceeds issue and that in order to get it, you had to have Taylor sign off on her legal rights?
No, sir. That's incorrect.
Isn't it true you got mad at Carlina and said you are choosing your own daughter over Chloe?
I don't recall.
Didn't you tell her that she needed to quit hiring attorneys and have Taylor go away?
No, I did not.
And when Carlina said no, you said, quote, "You must not love your granddaughter that much and do not have the respect for the woman in Ori's life."
I do not believe that's how the conversation went.
Isn't it true that you would drop off Chloe at Carlina's house?
Sometimes, yes.
Well, when you say sometimes, isn't it true your husband Ori works?
Pardon me?
Isn't it true your husband Ori works
Yes, he works.
and he works full time?
Yes, sir.
Okay. And isn't it true that you were the predominant one to drop off Chloe at Carlina and Jamie's residence?
Yes, sir.
And weren't you the one that predominantly picked up Chloe from their residence as well?
No, not all the time.
I didn't say all the time, predominantly, majority of the time.
No, probably about 50-50.
So 50-50 pick up and mostly drop off is what I'm hearing. Is that correct?
Carlina would drop Chloe back off at home sometimes.
Okay. So you'd still have arrangements with Carlina to do that.
Correct.
Oh, big sigh. Here's the thing, guys. We're actually going to stop right here. I know we're in the middle of it, but we're really in the thick of it to begin with. Here's the thing. I have good news for you. We are going to be doing extra shows this week. We're going to be doing 2 shows a day, 1 in the morning, 1 at night. So get ready to tune in. I think it'll be between 9:30 and 10 a.m. Pacific, which is an open time slot for the next little while. So I am going to, that is partly what I was working on yesterday. We're going to have, it'll be an hour show. That's it. It's not going to be long. It's an hour show. And then we will see how we do. Yeah, but we'll start tomorrow. Yeah, I'm picking up extra shifts so Credence and Mikey can stay on vacation. I'm picking up extra shifts for my own benefit as well. It will be fun. We'll be, it'll be, yeah. I think what we'll try and do tomorrow is hit a live court. We'll see what happens. We'll see how we do. And we'll revisit this case throughout next week. But that's right. You can expect 2 shows each day. Also, right now, we're going to end this and then we're going right into our members only. We're going to watch a tiny little bit of court. And guess what else? We are going to talk about ice cream. That's right. I want to hear all of your favorite ice cream combos. We are going to talk about all these amazing things because I'm going to the gym and then I'm going to get ice cream and erase the 2 of them. So, until then, yeah, that starts soon. It's already, I should have set this up to redirect there. I didn't. I never do. Whatever. You guys can find it. It's already posted. Remember that I love you. I am proud of you. And I will see you in the next video, which is like really soon. Okay, bye.
Ways down and ready